Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I wanted to share with you this case that came out at the end of last year, and this is called the Schultz versus Midland credit management case. And I wanted to share it with you for a couple of reasons. One, it involves one of the largest debt collectors around, this Midland credit management, or also Midland funding. It involves the Fdcpa, Fair Debt Collection Practices Act, an idea of what's called the least sophisticated consumer, a way that we measure or test what a debt collector does and say, does that violate the law? And then finally, this idea of debt forgiveness and how that can trigger some tax liability. And so all this comes together in this case out of the Third Circuit Court of Appeals, and this was September 24, 2018. So let's look at what we're talking about here. And this is the basic question here that the court is looking at is there's a debt collection letter that says that the forgiveness of debt may be reported to the IRS. And the question is, does that violate the Fdcpa? And so the district court, or what's called the trial court where this case was filed, said, look, that does not violate the law and could not constitute a violation of the Fdcpa, dismissed their putative or their class action that they wanted to have here. And the appellate court says, look, we disagree with you, and we think this is a violation. So let's kind of dig down into this. So we have Midland. They are sending letters on 3 separate accounts, and this is critical, and this makes all the difference in the world. None of the debts exceeded $600. And there's a cutoff for if you are dealing with forgiveness of debt that's under $600, then it does not need to be reported to the IRS. It's only when the amount forgiven is above $600 that it's to be reported. But look what all these letters say is they say if you pay your full balance, we'll report it as paid in full. If you pay less than full, we'll report your account as paid in full for less than full balance. Now that has to do with the credit reporting. But then we have this right here. We will report forgiveness of debt as required by the IRS. Reporting is not required every time a debt is canceled or settled, might not be required in your case. And so they sued because, as is pointed out here, it's only when it's $600 or more that it has to be reported, and all these were below $600. And so they filed this lawsuit where they're wanting it to be a class action. So I haven't pulled the actual case. It probably was limited to Pennsylvania. Just everybody in Pennsylvania that got a letter from Midland Credit that was under $600, and yet it had this sort of threat of we may report this to the IRS. And so here's what the trial court said. So this federal judge said, look, it did not threaten the reader of the letter with legal action. It cannot be taken, nor did it include anything false. When read in its entirety, could only have one interpretation, and that is, in certain circumstances, debt settlement may be reportable to the IRS. And so the court's saying, look, it's a true statement that sometimes we have to report forgiveness of debt. If you read the letters as a whole, there's nothing false about this. Well, the court disagrees, and it starts off and says, look, this Fdcpa was passed in 1977. Here's the reason why. Abundant evidence of the use of abusive, deceptive, unfair debt collection by many debt collectors. And this next part's interesting, and we've talked about this in other videos. There's really 2 purposes of the Fdcpa. One is to protect consumers by eliminating this abusive practice, but also for those debt collectors who do not violate the law. It's unfair for them to have to compete against people that are violating the law. So if you think in football terms, if my team is out there with 11 players and the other team has 12 players on the field, well, I'm at a disadvantage because they're cheating. And so we want a level playing field, not only for the consumers to get a fair shake, but also for debt collectors that are not breaking the law. And so the section we're looking at here is Section E, which says debt collector may not use any false, deceptive, or misleading representation. And then it goes on and it gives about, I forget what it is, 15 different examples of that. But this is the core concept is don't lie, don't deceive, don't be misleading, don't suppress information. Just be very honest. And so here's one example. The threat to take any action that cannot legally be taken or that is not intended to be taken. So I'll give you an example. If a debt collector says, they've not sued you, and this is on a credit card debt, they call you and say, if you don't pay it, tomorrow I'm garnishing your bank account. They don't have the right to do that. They've got to get a judgment first against you. And so legally they cannot do that. But let's say that in their mind they say, well, we were never going to really do that. We were just saying it. Well, that would violate the law because they threatened you with something that they had no intention of doing. So another example is they say, if you don't pay this by Tuesday, we're going to file suit against you on Friday. But either they can't sue you, maybe statute of limitations is over, maybe they're not licensed to file suits, maybe they don't actually own the debt, or let's say they have the ability to sue you, but they never intend to sue you. Well, again, that would violate this section. And then this is kind of a general section. This is subsection 10 of this 1692E. It's any false representation or deceptive means to collect or attempt to collect a debt. And so how do we judge if something is deceptive or misleading or misstatement, misrepresentation? Well, we have this idea of the least sophisticated debtor. And so the least sophisticated debtor says we're not necessarily looking at the actual plaintiff that filed the suit. We're just saying in general, take somebody, and we're not saying that they're just taking a crazy position, but in one court case even says this, that we don't expect you or we don't judge you by being a slick Philadelphia lawyer, okay? And so here's the idea, is that requires more than simply examining whether it would deceive or mislead a reasonable debtor, because a communication that would not deceive or mislead a reasonable debtor might still deceive or mislead the least sophisticated debtor. And so the idea is protect all consumers, the gullible as well as the shrewd, the trusting as well as the suspicious, from abusive debt collection practice. Let me give you an example. Debt collector says, if you don't pay this, I'm going to come to your house, kick down your door, and shoot you with a shotgun. Now, we might go, I seriously doubt Midland Credit Management, that has thousands of employees, is going to come kick down my door and shoot me. And so if we're looking at this under what's called common law fraud, most states have that, the court would say, well, you can't win on that because it wasn't reasonable to think they were really going to do this. But under the Fdcpa, we can say, even if I know it's false, the fact that you tried to deceive me, the fact that you tried to mislead me, that is enough to violate the law. And so the court points out the plaintiff's burden is low under this objective standard. She need not prove she was confused or misled, but only that the least sophisticated consumer would be. And so here's the basic argument from the plaintiff here. They argue that including the language "we will report" as required, Midland present a false or misleading view of the law. And what's the purpose of that? In other words, why would Midland do that? Well, it's to scare or intimidate the plaintiffs into paying the outstanding debt listed, even though they knew that discharge would not result in a report to the IRS. And the court simply says, we agree. And so here the reporting requirement is not applicable because none of the debts totaled $600 or more. And it clearly states only discharges of $600 or more must be included. And so the court says by including the reporting language on debts less than $600, so again, if this is more than $600, this case doesn't apply. So you get a letter from Midland or Calvary or Portfolio and it's for $1,000 or $10,000. It might still be deceptive, but this case is specifically talking about $600 or less. It says, by including the reporting language, we believe the least sophisticated debtor might be persuaded into thinking that the discharge of any portion of their debt, regardless of the amount discharged, may be reportable. Now here's the counter to this. Midland argues that in order to conclude be misled, you'd have to read the first sentence isolation, paying no attention to the second qualifying statement, that is, reporting is not required every time a debt is canceled or so. It might not be required in your case. Here's a problem with this. And I'll give you an example. We had a company, Portfolio Recovery, years ago. They sent our client a collection letter. And this was like a debt that was 10 years old. And it said, we may report this on your credit report. Here's the problem. You can't report it on the credit report. 7 or 7.5 years is the limit for negative information. So we were way beyond that. But Portfolio says we may report it. So we sued them for fraud. And their argument was, well, I mean, it's just a form letter, and, you know, we didn't say we would report it. We just said we may report it. And our argument, this is, 10, 15 years ago, is, look, the fact that you said it's possible to report it when you know it is impossible, that violates the law. And that's what the court does here. Court says, even with this qualifying statement, the least sophisticated debtor could be left with the impression reporting could occur. And this is exactly what happened here. There was no possibility of the IRS reporting in light of the fact debt was less than $600, but use of the conditional suggested the reporting was a possibility. And so Midland then argues there's this idea of if it's going to be bizarre or idiosyncratic, not a word I normally use, but it's saying if you're taking some absurd position, some weird interpretation of a letter to sort of twist it into making it deceptive, courts don't have to accept that. And the court goes, no, that's not the case. See, Midland argues the use of the conditional might should signal that only under certain circumstances. Here's the problem, is that for the plaintiffs, under no set of circumstances will reporting ever occur. And so something could be true and yet still deceptive. So look at this language. Even if the language in the letter is true, it can still be deceptive where it can be reasonably read to have two or more different meanings, one of which is inaccurate. So Midland's saying, well, we might do this. That's deceptive because they know there's no way that they can report this. And so, yeah, is that a true statement? Well, I guess it's true in the sense that it might be reported, meaning that it won't be reported, but you see that leaves in the consumer's mind the possibility that it could be reported, and that is simply not true. And so then we go down to this. The Fdcpa sweeps broadly is not just outright lies it condemns. And so reasonably interpreted imply will take action has no intention or ability to take. The debt collector fails to clarify that ambiguity, does so at its peril. And that's the point here, is that Midland intentionally chose to do it this way, making it confusing. So people would think, oh, wow, if I don't pay the full amount, I may get hit with taxes on it, when it was impossible to be hit with taxes on it. And so look at this, because I think this is kind of the practical argument that the court makes. It says, we recognize Midland uses form letters when contacting its debtors, but convenience does not excuse a potential violation of the Fdcpa. Therefore, we're obligated to reverse the order of district court as a reasonable juror may find a violation of the Fdcpa in this instance. So Midland saying, well, look, we send out 100,000 letters a week or a day or whatever it is. We use form letters, and you can't hold us responsible for this. And the court goes, yeah, we can. You know that under $600 it can't be reported to the IRS, but yet you put that language in letters involving less than $600. So a couple things. I just wanted you to see how all this fits together. And then certainly if you've gotten one of these letters, whether from Midland or Calvary or Portfolio or whoever it is, that says we might do something when you know it's impossible for them to do it. So credit reporting after the time has expired, suing you after statute of limitations has expired, or threatening the possibility of reporting to the IRS when they can't do that, then you may very well have a claim. And I would suggest that you get with a lawyer. You can certainly get with us, especially if you're in Alabama. If you're outside of Alabama, we can work with a lawyer in your state or probably file the case in Alabama anyway, because all these companies do business in Alabama, so we can get what's called jurisdiction over them in Alabama. But the point is, just keep this concept in mind that when they lie, even if there's kind of a way it can be true, if there's a way it can be false and it's something significant, then I would definitely pursue that. So hope that this is helpful and that you enjoy going through this. I'll put the link to this as in the last case. You can just really type this into Google Scholar, but I'll put the actual link so you can read it there. And hope that this is helpful to you, and look forward to talking to you in the next video. Thanks. Bye-bye.